Bankruptcy is a debtor protection law. So as we get started to talk about bankruptcy law, I want to tell you that I've provided a link to the Northern District of New York Bankruptcy Court's website. There you can see how the court is structured. You can see the actual bankruptcy code and the various types of forms that are related to the various bankruptcies. So you have access to that if you want to look through that as we go through the topics. So bankruptcy. Historically, debtors, they had very little rights when it came to being overextended or where their debts were more than their assets. But today we have lots of protections for debtors, and they are found in what's called bankruptcy law. So what is it? It's a legal proceeding that can help individuals and businesses who owe more debt than they can pay. They don't have to be completely insolvent. They can still be solvent. The key is as long as they owe somebody something. So it is a federal law. It's strictly federal law. The federal courts have exclusive jurisdiction over bankruptcy cases. This means that the bankruptcy case cannot be filed in state court. It has to be filed in a federal court. The U.S. Constitution prohibits the states from impairing what's called the quote-unquote obligation of a contract. So states cannot provide a means for discharging a debtor from any debt, of course, unless the debtor has paid in full and the creditor isn't relinquishing whatever. Maybe there was a security related to it. Then a state court can get involved. But state courts don't have the authority to just relieve somebody from their contractual obligations. It is a federal statutory law. The Constitution gave Congress the power to establish a uniform law on bankruptcy. It has been amended several times. The current law was adopted in 2005. It's called the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. I think the book does a good historical background relative to the code. We call it the Bankruptcy Code. And it is statutory, like I said, versus common law. But when there are some issues relative to interpretation of what the statutory code is, courts get involved, and then they make what's called case law, and that case law becomes our common law. If you remember way back at the beginning when we were talking about the court system. So with that said, although bankruptcy law is federal, there are state laws that kind of come into play. State laws involving secured transactions, as we talked about, liens, judgments, and something that we call exemptions. There's personal property that is not subject to bankruptcy. That's set forth in state law. We'll talk about that more specifically. But there is state law that kind of gets involved in the underlying parts of a bankruptcy. The primary purpose of the law is to give an honest debtor a fresh start in life. They're relieving the debtor most of their debts, and it's to repay creditors in an orderly manner to the extent that the debtor has property to make those payments. So that's the point, primary purpose of bankruptcy law. How the court is structured. The bankruptcy court is its own court, and it's under the authority of the U.S. District Court. So it only handles bankruptcies. As you can see in the chart, it's kind of at the bottom. It's its own court. And if there's any issues relative to decisions of the U.S. Bankruptcy Court, the aggrieved party can appeal to the U.S. District Court to review. And then up again the chain to the U.S. Court of Appeals, and then possibly the United States Supreme Court. But it all starts in bankruptcy court. It is its own court, as you can see from the chart. And like I said, primary purpose, debtor gets a fresh start, and it provides an orderly manner to repay creditors when the debtor has property that's available. So there are a number of cases that are filed under bankruptcy courts. Why do we have these laws? As I said earlier, fresh start for folks, and an orderly payment to the creditors. But why bankruptcy law in a modern society? Is it important? Why do we have them? We have numerous chapters. Vast majority of cases are filed under the three main chapters of the Bankruptcy Code. We have Chapter 7, which is a liquidation liquidation chapter, Chapter 11, the reorganization chapter, and Chapter 13, adjustment of debts. The book mentions some others. I got the list here. Chapter 9 is for municipalities. They need debt adjustment. Chapter 12 for the farmers for adjustments. And Chapter 15, the cross-border bankruptcies, when people live or have debts or businesses that cross the borders or in different countries. But we're primarily going to be focused on 7, 11, and 13. But why bankruptcy laws? Before the 2005 reform, bankruptcy was out of control. It was soaring. There was an average of 500 million per year, and in 2004, 1.4 million filings were done. That prompted banks and creditors, the credit card companies, they wanted to kind of restore some sort of personal responsibility on the debtors. It was very easy to go in and just have your debts wiped out in bankruptcy. They were losing lots of money. It would cost creditors $900 million. Some lost $44 billion, some banks, because the older laws had some loopholes and some incentives for filing. Back then, student loan debt was dischargeable. So the fact that some bankruptcy debtors were able to pay a significant portion of debts, they still chose to be discharged, even though they were making money and could have paid towards their debts. So that prompted a big change in the law, which came in 2005. But before we jump into bankruptcy, because it is a big deal, it's kind of like the last effort, the last thing a debtor should do. But there are alternatives, okay? Debtors get in over their heads. They're receiving collection notices. They're being threatened with lawsuits from their creditors. It has long-term effects on their credit reports. There's stigma. There's always subject, to higher interest rates, especially when you go through a bankruptcy. So sometimes there's alternatives, okay? Creditors can choose to do nothing against a debtor. Some of the reasons why they choose to do nothing is that the expense of going through a collection might exceed the debt than what they're looking for by the time they pay for the court fees and the attorney's fees, and in the end they may not get anything. So sometimes they choose to do nothing. Sometimes they expect the debtor to pull through. Maybe it's just they're in a bad time, they lost their job, but once they get back on their feet, they'd be able to pay the creditors. Sometimes creditors rush to satisfy their claims through legal proceedings because there might not be enough money to pay out in a bankruptcy. And a lot of times they do this number 4 or number 3 on my list here, the composition agreements. These are agreements that are reached outside between the debtor and the creditor. Maybe the creditor just takes a lesser amount to satisfy the debt. At least they got something. And then in some instances, in state courts, a court can appoint what's called an administrator or a receiver, where the debtor puts all their assets in a pool in state court, or it's being held, and it's for the benefit of all the parties. The administrator it kind of works a little bit like a bankruptcy, but we're just talking about property that is a secured piece of property that can be held by an administrator. So those are some alternatives to filing for bankruptcy, but let's jump right on into the bankruptcy process. So in the chapters we're going to talk about 7, 11, and 13. They share a lot of components. So what I'm going to do is I'm going to kind of give you the list of the shared components. Then we're going to talk about the biggest one, the Chapter 7, and then I'm going to tell you the differences relative to Chapter 11 and Chapter 13. So the whole bankruptcy process starts with the filing of a petition. And the filing of the petition in Chapter 7 and Chapter 13 can be Chapter 7 and Chapter 11 can be done voluntarily or involuntarily. I'll explain the difference when we go through the actual Chapter 7. So filing the petition means all other legal proceedings will be stopped, and I'll explain that in detail. Then the court orders what's called an order of relief, and then there's some sort of meeting between the creditors and the debtor. Some in Chapter 11 and in Chapter 13, there's some sort of structure payment plan that happens. And then the plan gets carried out, and ultimately any debts that are not satisfied get discharged. So that's the general process relative to how a bankruptcy works. But before a person can file for bankruptcy, when they go down to get information relative to a bankruptcy, they have to, the clerk has to give them information. Either has to come from the clerk or it has to come from an attorney, but this happens before filing, okay? The clerk must give the debtor notice of all the types of bankruptcy relief and ensures that the debtor has full information about the bankruptcy process. The other thing that is required to be given to individuals whose primary debt is consumer debt, the purchase of goods for homes and family use. When we're talking about an individual, not businesses, we're talking about individuals who are filing for a Chapter 7 or a Chapter 13. And I'll tell you where it comes into play as we go through each one. They have to be provided information regarding credit counseling. And this is kind of new to the 2005. This never had to happen before, is that the individual has to take a credit counseling course before they file for bankruptcy, and that has to be done within 180 days of that filing before anything can happen for them. And ultimately, before their discharge of any debts, they have to take a financial management course. So those things are mandated for individuals, the consumers who are seeking to discharge consumer debt. Credit card debt is the main focus of this credit counseling program that they must attend. So the first chapter we're going to discuss is the liquidation proceeding. This is what we call a straight bankruptcy. This is the most common one that people apply for, the one that most people are familiar with when you hear bankruptcy. When businesses and individuals file for bankruptcy, this seems to be the one that goes to everybody's mind. What is it? The debtor turns over all assets to be sold. Right, the liquidation occurs when the debtor has turned over all the assets to a trustee. A trustee is an individual that handles the administration of the debtor's estate. It's usually an attorney who specializes in bankruptcy, and we'll talk a little bit more about the trustee, who then sells the non-exempt assets, because there are some assets the debtor gets to keep, and then distributes the proceeds of the sale among the creditors. So that's the gist of a Chapter 7, and we'll start piece by piece. So who can file for Chapter 7? Individuals, partnerships, corporations, not railroads, insurance companies, or banking institutions. And when I say individuals, that also means sole proprietors, individuals that have their own business. So these are the folks that can file. And just because you can file doesn't mean you are eligible for a Chapter 7 liquidation. But there are some things that we go through for a checklist here. So you may be able to file because you're one of those people listed that we just talked about, but you might not be able to get the ultimate discharge. So some of the things that you have to go through is you must pass what's called the means test. We'll talk about that, which determines whether you qualify to file Chapter 7. You cannot have had a Chapter 7 discharge in the past 8 years or a Chapter 13 discharge in the past 6 years. And you cannot have filed a bankruptcy petition in the previous 180 days that was dismissed because you failed to appear in court or comply with court orders, or you just voluntarily dismissed your own filing because creditors sought court relief to recover property or gone some other route. So if you had filed and then you either it got dismissed by the court or you pulled out on your own, you cannot then, change your mind and a month later file again. You have to wait 180 days. So what are the liquidation proceedings? First thing that we're going to talk about is filing of the petition. And you file the petition with the appropriate bankruptcy court. And that is the one where the debtor resides. Okay, so what we're talking about federal court, so there's not a federal court on every street corner. So think back to the chart that we were looking at and dig way deep to the beginning when we were talking about courts and such. But let's say I reside in Plattsburgh, and we know that I have to file in federal court. okay? There is a federal court here in Plattsburgh, but we do not have a bankruptcy court in Plattsburgh. So we have to see where the bankruptcy courts sit. The federal courts are divided in New York State in districts. We have the Northern District, the Southern District, the Eastern District, and the Southern District. So you'd have to look at a map to see where you were. I'm in Plattsburgh. I'm in the Northern District of New York. So then I have to see, well, where are the bankruptcy courts in the Northern District of New York? There's one in Albany, there's one in Utica, and there's one in Syracuse. So what happens is I file. There's a filing system. It's online these days, so you file. And then you get shuffled into which court the court will deem you appropriate. Most likely it would be in Albany because that would be the closest to where I am, but it could end up in Utica, it could end up in Syracuse, depending on the court's calendar for the bankruptcy court. But the key point is I could not file for bankruptcy in federal court in Vermont or in Connecticut. It'd have to be where I am. And the one who files pays the fees. So if I'm filing, I'd have to pay the fee. Our petitions can be done voluntarily or involuntarily. The voluntary bankruptcy petition is the petition that's formally filed by the debtor. I'm asking for what's called an order of relief and then ultimately a discharge, and we'll talk about those things. We'll break it down, but this is the gist of filing a voluntary petition. There is no minimum number of creditors that have to be listed. I may just have one big one that I can't pay, or I might have numerous ones. I must state that I understand that I have been advised of all the other types of bankruptcy available. Remember, the clerk has to give that information. It can also be provided from an attorney, but I have to say that I have gotten all of that, and I acknowledge that I have all of that information. I also have to provide a detailed list of all the assets that I have, the liabilities I have, income. It is a crime to supply false information. I have to indicate all of my creditors and their addresses and the amounts due. And I also have to provide a certificate that I completed the counseling class within 180 days of my filing, okay? So all of my pre-petition assets, that means right up to the point I file, is going to become what's called the bankruptcy estate. So the estate property, it includes all of my, as I said, all of my pre-petition assets owed to the debtor. So if I own a home, I own a car, I own a Van Gogh painting, I have a diamond ring, I have a classic car, maybe I have a stamp collection, all of these things, even if they're already paid for, all of these things that are assets will be a part of the bankruptcy estate. Now let's say a week after I file, I go out and I buy a 70-inch flat screen TV and a Macintosh computer. Is that going to be part of the bankruptcy estate? Possibly, and we'll talk about that. But my point I'm going to make right now is I bought it after I filed, so technically not. But I might be deemed to have abused the system for potentially racking up more debt. What if I go out a week before I file and ran up my credit card? That might be a problem. So we'll talk about those when we talk about bad faith and abuse. So I don't have to be completely insolvent or completely unable to pay to file for bankruptcy. Husband and wife can file jointly, or they can file under their own separate single petition. The point is I have to demonstrate that I owe money to somebody. There are some exceptions with regards to property that the debtor acquires after filing the petition that would be subject to the estate property, because generally property acquired after the filing of the petition is not considered part of that property, but there are some exceptions. If the debtor receives within 180 days of filing the petition an inheritance, life insurance, property settlement with a spouse, those items will be part of the estate. So you file for bankruptcy today, your aunt passes away in 2 months, leaving you $5,000, that $5,000 now becomes part of the estate. If there's income from property that's owned by the estate after the petition is filed, let's say you have rental income, maybe you get royalties, you received a royalty check from a book that you wrote last year, that book is part of the property, but you're receiving money that's coming after the fact, that is still going to be part of the property. Of course, there are some exemptions that we're going to talk about that people get to keep, even though they're part of the estate, the bankruptcy estate. There are some items that are exempt from being there that will come out. So now we've filed the petition. But that petition can be subject to dismissal at this point. We're going to determine that the filing isn't, to determine that the filing isn't abusive, the petitioner may be subject to dismissal at this point, okay? So to determine whether or not there's abuse, we're going to use what's called the means test, okay? If a debtor fails to meet the means test, it must be completed to determine whether they qualify. If they do not pass, then they're not going to be able to file for Chapter 7. It's automatically deemed an abuse. It does not mean you're going to get arrested and something's going to happen to you. It's just going to be, no, you can't do Chapter 7. You either do something completely different in the bankruptcy world, pick another chapter, or you're kind of SOL. So what is it? What is the mean test? I did put a link to New York form for completing this. It looks like a tax form. It's like 9 pages long. Usually it's filled out with an attorney beforehand. Someone would get legal advice as to say, hey, you can't file a Chapter 7 because you don't meet this mean test. It's already usually determined. But people who can file bankruptcy on their own, and they don't get that until this point. So the bankruptcy means test determines who can file for debt forgiveness through Chapter 7. So it takes into account your income, expenses, family size to determine whether you have enough disposable income to repay your debts. Although it was designed to restrict the number of debtors who can get their debts forgiven, this test is fairly easy to pass. Those who don't qualify, though, for Chapter 7, and you want to, or if you want to retain certain assets like your house or your expensive car, you can choose to do a different bankruptcy, usually 13, and we'll talk about that one. So how does this means test work? It's a 2-step process. And step 1, that's the first part. So how does this work? Okay, 2-step, lost my spot here. The means test is 2 parts, both designed to see if you have any disposable income that you could put towards paying off your debt. The whole point is they want to see if you have money, if you have income, and you have enough of it, you can pay the debt versus getting completely discharged. This is really for the unsecured creditors, those credit card companies. 2 parts designed to see if you have any disposable income. The test is only for those who have primarily consumer debts, okay, like credit cards, medical debt. You don't need to pass the means test if your debt is mainly from a business that you own. It's different. So step 1, the first part of the means test checks whether your household income is below your state's median income. And there is a list that's provided in the court, and it changes every year, income, because of the fluctuation in the economy. And you might see the numbers. I guess I'll take this time here to say, in some of my examples, I'm going to use numbers. They're more current numbers than the numbers that you might see in your book. I'm not testing you on numbers because it changes every year with regards to how much money people make and so forth. So numbers not important. The system is, what the process is. So the first part, your average household income is determined by averaging your monthly income over the last 6 calendar months. Because they use 6 months, it's based on the past 6 months because there are adjustments for any recent or any upcoming changes. Say you had a job for 4 months for the past 6 months, but now you're unemployed. The mean test is going to take that drop in its factor. It's going to be factored in as that drop. And on the flip side of that, if you recently got a new job and are making more money, then the increase will be considered as well. So that's why they don't just take what it is happening right here, right now in your world, but they look at it for the last 6 months. In New York, I just gave you the top 4. If there's a one family, if you're one person, single family household, that's our median that you got to meet. If you're below that medium, you can file for Chapter 7. If you're above that medium, then you have to do something different. If there's a 2-person household, the number's a little over 59.5. And then 3, and then a 4-person income. And there's a whole list on the government's website or on the bankruptcy website, depending on your state and how many people are in your household. So if you're below the median income, you've passed the means test, and you can file for Chapter 7 bankruptcy, and it's pretty much that easy. Step 1, anyway. So step 2, if you're over monthly income, you take your monthly income and you subtract your reasonable living expenses over the last 6 months. Okay, things such as rent, groceries, clothing, medical costs, they make up what is called, quote unquote, allowable expenses. That's the word that the government uses, or the code uses, allowable expenses. And what's left after allowable expenses is deemed disposable income that you can put towards paying off your debt. Now, the allowable expenses are based on what the IRS standards are, okay? It's based on what both national and local standards, which is ultimately used by the IRS. So national standards cover those items like food and clothing. Local standards cover things like housing and car payments. And there's a list. If you looked at the means test sheet, there's a list. So now you know your disposable income. You multiply it by 60, and the number is supposed to come out of a 5-year repayment plan. So let's look at some examples. All right, so even if you've met the medium test, or you didn't pass the medium test because you're too high above what the medium monthly income is or annual income is, you could still qualify for a Chapter 7 if your disposable income is shown to be too low. So here's our numbers, okay? If you're below $100 a month, you're still going to qualify for a Chapter 7, okay? And the total for over 5 years is $6,000. You're still going to qualify. So if you have $98 or exactly $100 or $85 of disposable income, you're still going to qualify. If your disposable income is $10,000 after the 5-year calculation, you're automatically going to be denied. You're going to be deemed that's suggesting is going, the law presumes that you're abusing the debtor abuse if income exceeds that amount, okay? And like I said, you don't go to jail over it. You just have to be subject to dismissal or change your options, and the option is Chapter 13. So what happens if you're in the middle, okay? And I did the calculation for that. It's $160. You need to be like $166.67. Somewhere between there is a weighing. Now we're going to do this weighing, okay? So the law is going to presume that the debtor it's debtor's abuse if the income exceeds $10,000 or $166.67 a month, 67 cents a month. So now the debtor has to show otherwise, okay? So let's talk about some examples. Susan, who is 28 years old, owns a home and a car and is currently employed, earning $50,000 per year. She also has $12,000 in credit card debt. Susan files for Chapter 7, listing her monthly net income of $2,900 and the expenditures of $3,000 for a deficit of $100. So my question is, would she qualify for Chapter 7? She would, because of the 100. She certainly meets. She has to go to the second part of the means test because we're going to use New York, so she makes $50,000. She's above the medium, so now there has to be a calculation, and you do the calculation based on those numbers, and she has $100 left, and we know $100 below, we're going to qualify for Chapter 7. But what if she did not state that she makes a $300 monthly contribution to her retirement plan. And the question is going to be, is that an allowable expense under the IRS standards? And they have to look at the circumstances. Is that something that should be allowable? Well, she's 28 years old. She makes $50,000 a year. If we did the calculation, she would be $200 to the good, right? She'd be $200 to the good. And how much would she have? She would have $12,000, right? If she didn't give that $300 contribution to the retirement plan. So this is the type of thing that the court looks at, and they're going to take it. And in this case, she's 28 years old. She can not contribute $300 monthly. Now she can contribute for the next 5 years to pay off the $12,000 credit card debt. So she would be denied Chapter 7. She'd be required to go to a different chapter or do something completely different in this instance. So the code is trying to assure that consumer debts with the ability to repay their debts are not declaring bankruptcy, right? So they're going to scrutinize a full-out discharge, and here she could totally pay this over the course of 5 years. Some of the exceptions that are made are for medical conditions. Sometimes military service will take into consideration. What if the income is between 100 and 166? So let's go here. What happens is the court will measure against the debt, 25% of the debt. The amount that you have as disposable income is measured against the percentage of the debt. That's the benchmark. If your debt exceeds the disposable income by 25%, then Chapter 7 will be allowed. So let's say the debt is $50,000 and the disposable income is $125 per month. So the debt's $50,000. And how much is 25% of $50,000? $12,500. And if you multiply 125 times 60, you get $7,500. So will this debtor, be allowed to file for Chapter 7? The answer would be yes, because 25% of the debt is more than what the disposable income is. If the debt is $50,000 and the disposable income is $150 per month, same calculation, 25% of $50,000 is $12,500, and then you multiply 150 times 60 and you get $9,000. The question is, would she be allowed to file for Chapter 7? The answer is yes, because the 25% of the debt is more than the allowable disposable income. Last example, $25,000 in debt, and disposable income is $125. 25% of that of $25,000 is $6,250, and 125 times 60 is $7,500. So would this person be allowed to file for Chapter 7? The answer is no, because the disposable income is more than the 25% of the debt. So that's how that works. And I'll say the book does a good job at outlining this test and doing the summarizing. So if you need a little bit more, you can review the book. You can shoot me an email always and ask. But you have to meet the means test to get a Chapter 7. Otherwise, you're going to be subject to dismissal or forced to do another chapter in the Bankruptcy Code. There are some other grounds for dismissal: failing to provide documents timely, conviction for a violent crime or drug trafficking offense, failure to pay your domestic support obligations, such as child support, spousal support, alimony, and abuse of the unreasonable delay, being prejudicial to the creditors, unreasonable delay to the prejudice of the creditors, I should say, and just abusing the system. The abuse of the system. They look at the totality of the circumstances. If you acted in bad faith with regards to filing for bankruptcy. And we'll talk a little bit more about bad faith and abuse a little later on after we cover the rest of the chapters. So the next petition, we're still filing the petition here. It can be done involuntary. And what I mean by that is creditors force the debtor into bankruptcy by filing its own petition. They try to force the debtor to surrender their assets so that the proceeds can be used to distribute among them. And don't think, I mean, yes, it can happen to an individual, but we see this a lot more with corporations and businesses. This does not apply to farmers or charitable institutions. They cannot be forced into bankruptcy. But there are some requirements that need to be met for the filing purposes, okay? If the debtor has 12 or more creditors, 3 or more having unsecured debt totaling up to at least, and this is the number that is current, $14,425, they must join in the petition. Or number 2, if the debtor has less than 12 creditors, 1 or more having unsecured debt, may file. That claim is the same, by the way. If the debtor has fewer than 12 creditors, 1 or more having an unsecured claim of $14,425, may file. In both instances, the debt must not be undisputed, so the debtor acknowledges the debt. So you may have a different number. Like I said, we may have a different number in the book. This is the current number. I'm not testing you on the number, testing you on the concept. So let's talk about the concepts. Put these two in play. We have Poor R Us company is not paying its debts as they become due. Its creditors are A, who's owed $15,000, B, who's owed $8,000, and C, who's owed $10,000. Who can file an involuntary petition? That would be number 2 that would come into play because there's fewer than 12 creditors. So only A alone, because A has more than $14,425. So A can file. B alone can't, C alone can't, but B and C together can because they would exceed that cap. So Poor Inc. is unable to meet its current obligations as they are becoming due because of severe business difficulties. It owes over $20,000 to a dozen different creditors. One of the unsecured creditors is Green. Green is owed $15,000. Can Green file an involuntary petition? Green meets the cap, but no, he cannot. And why not? Because rule number 1 applies here. There's more than 12 creditors, so he needs 2 others to join him. So when there's 12 or more creditors, 3 or more having unsecured debt totaling. So Green can file, but maybe there's 2 others. Maybe they have $500 each, or even smaller amounts. But Green can't do it on his own. So upon the proper filing of a bankruptcy petition, from the date of the filing, you don't have to have the determination yet of whether your filing was proper. So upon the filing, what happens is an automatic stay. It's not a court directive. It's not a special court order. Is when the petition is filed, whether it's done voluntarily or involuntarily, everything that has transpired against the debtor stops. It's halted. We call that a stay. So upon the proper filing of a bankruptcy petition, on that date, you don't have to get the determination of whether the petition is proper. There is a suspension of all judicial proceedings and litigation by creditors against the debtor. So the creditors cannot commence any actions. They can't start any actions against the debtor or continue with any other proceedings they might have. They can't take action to repossess property. They can't enforce any judgments that the creditors may have gotten against the debtor. They can only now proceed through the bankruptcy court. They need to either seek permission to proceed, or they just have to take it through the process because now they're listed as one of the creditors from the debtor. There is a separate process for secured creditors who may want to repossess. They can certainly ask the court to be excluded from the stay. They're going to have to show that they do not have adequate protection under the stay. They may lose their interest through the stay. The court may allow them to get repossessed, allow them for permission to repossess, or direct the debtor to pay for a secured loan. So, for example, GM Trucking borrows funds from Middletown Bank to buy 2 trucks, giving the bank a security interest in the trucks, right? So GM fails to make its monthly payments for the 2 months and then files a petition in bankruptcy, okay? So under the bankruptcy law, the bank is prevented from repossessing the trucks because the filing of bankruptcy stops any proceedings. But let's say the trucks are rapidly falling in resale value. They're soon going to be worth much less than the balance that's due on the loan. Is there anything the bank can do? Yes, the bank can go to the bankruptcy court and ask for a number of types of relief. Give me the trucks so I can sell them, so I can repossess them and then sell them. If they had already started a proceeding, they may ask, let us continue our proceeding. They have to get permission. The bankruptcy court might direct the debtor to make 1 or 2 payments to that particular debtor, or may require them to continue paying on that if they plan to keep the trucks. So there is some relief for secured creditors with regards to their debt, because they have a debt that is a priority. If the creditor is aware of the stay and continues to move forward or try and take property or continue their case, what happens? They can be subject to damages, paying attorney's fees, even punitive damages if their conduct is really egregious. So how about this, for example? Do I have it on here? I do. Soon after graduating from Applied Science University, Britta files a Chapter 7 bankruptcy petition. Before the court finds that Britta's petition is proper and enters an order of relief, she requests a transcript from the university. It refuses her request, claiming that she owes more than $6,000 in unpaid tuition. Can she obtain her transcript despite the unpaid bill? The answer is yes. The university has violated this automatic stay. The school here is attempting to collect a debt. She's filed for bankruptcy protection. So the university cannot continue to enforce their rules. So they would have to turn that over. There are some exceptions to this stay. When an action concerning paternity, alimony, or child support, those things are outside the scope of the bankruptcy court. And if there is a case against one of those types of cases against a debtor to pay alimony or child support, those can continue. So those are my exceptions right there. An order for relief. This is also automatic, but once the petition is found to be proper, okay? It has to have met the means test, and this Chapter 7 liquidation is moving forward. So we have our filing of the petition, the automatic stay happens, and now the court has deemed everything is good. This petition is good. The court grants, basically it's the court granting assistance to the debtor and can say the bankruptcy can continue. This does not mean, oh, you're done, discharge. No, this just means everything is proper and the court is relieving the debtor of having to pay the debts that are listed in the petition. Like I said, just granting some sort of early relief. Okay, you don't have to pay. We're going to continue on and we're going to either restructure this or do what we need to do. But the bankruptcy can continue, okay? We're not to the discharge point yet. And this is automatic, okay? Once it's deemed perfect. Once it's deemed proper, I should say. The petition is deemed proper, not perfect. So then there is something called a creditors meeting, okay? It's within a reasonable time after the order for relief is granted, but it can't be less than 20 days and it can't be more than 40 days. So as you can see, there's a very small window. The court must call this meeting of the creditors. At that point, a trustee is appointed, and they're authorized to take control of the debtor's property and assets. We'll talk a little bit more about the trustee in a moment. The debtor must attend, and they must submit to an examination under oath. Who's doing the examination? The trustee and the creditors. They want to basically flush out the debtor's financial affairs, make sure the petition has everything in it. It's supposed to have everything in it. Also wants to make sure the debtor's not concealing anything, okay? So a failure to show or make any false statements will subject the debtor to dismissal and possibly perjury since they're under oath. So at this meeting, the trustee ensures that the debtor is aware of the consequences of the bankruptcy and the availability of the other forms of bankruptcy. So that's what happens at this creditors meeting. We want to make sure all our creditors are there, the debtor's financial affairs are in order. They're also going to explore, like, what do you spend your money on, and do you have any sort of money management issues? They're going to flush all of that out at this creditors meeting. So the trustee, they have lots of powers and duties. Their main duty is to administer the estate, the bankruptcy. Their main duty is to administer the estate. That's therefore they're accountable for administering the debtor's estate. They collect the debtor's property, even if it's held by a third party. So let's say the debtor is owed money from the neighbor. That money owed from the neighbor is considered estate property, and the trustee has the duty and power and can get that money that's held by third parties. They have to sell these, and even if it's an asset, they sell assets. They reduce it to money for distribution. Their goal is to preserve the interests of both the debtor and the unsecured creditors. Our secured creditors have a security interest in certain property, and some of those property might be deemed exempt. Most of the property that has a security lien, secured transaction, a car, a home, are going to be deemed exempt, and we're going to talk about exempt property in a moment. But continue on with the duties of the trustee. So when they take possession of property, they can do what needs to be done. Most of the time they have to have it appraised. If a Van Gogh painting, they have to have it appraised. They're going to examine the debtor's filings and all of their records. They may, if the debtor is a sole proprietor or if it's a corporation or partnership, they may even take over the business to make sure it's running properly. They have to separate the exempt property from the non-exempt property. They make sure that the means test is met. They are required to keep careful records of the property and the sale of the assets during the process. They have to keep a proper accounting. They have a duty. Their powers, they have lots of powers as well. They have the power to sue. If they have to sue a third party to get to the debtor's property, they will, and they can. They also can be subject to be sued as well. They can assume or reject contracts that the debtor has entered into. They can expire leases. They have the right to obtain credit for the debtor. They have the right to void any liens against the debtor. For example, a debtor has exempt property, which is a home, right? Let's say they have a real estate in this example. A debtor has exempt property, but it's hindered by a mechanic's lien. The trustee can void the mechanic's lien. It has the ability to void preferences and cancel any fraudulent transfers. Let's say a debtor is favoring one creditor over another. Usually they do this within 90 days of filing, especially if they do it within 90 days of filing. The trustee can void it and then recover those payments. So for example, they can cancel a fraudulent transfer that was made by the debtor within 2 years of filing a petition with intent, if the intent is to hinder or delay or defraud a creditor. Mary's planning to petition for bankruptcy, so she sells her gold jewelry that's worth $10,000 to her friend Diane for $500. Diane agrees, But she also agrees that in the future she will, quote unquote, sell the jewelry back to Mary for the same amount. Is there something going on there? Yeah, she's trying to hide that jewelry and keep it out of the bankruptcy court. So things like that the trustee can undo. And that example is called avoidable preference. And I actually just went through these examples. Take a look at them again. Now we're going to talk about the exemptions. There's property that does not go into the estate. Even though we're liquidating, selling assets, getting the cash, paying off the creditors, giving the debtor a fresh start, there are some property that's exempt from going to the estate. Why do we have exempt property? So basically the person won't be made poor, impoverished at the end. Like, oh, you don't have anything, you don't have a place to live, you don't have a car, you don't have clothes. Like, the whole point isn't to wipe you completely clean, just to give you a fresh start. So we have state and federal exemptions. So despite the Constitution's mandate that Congress shall establish a uniform bankruptcy law, states have convinced Congress to allow non-uniform exemptions. What do we mean? Why that? States have the power to pass legislation to prevent debtors from using the federal exemptions. There's a majority of the states that have prevented. You have to take the state's exemptions, and those who haven't made it mandated gives the debtor the choice, whether you want to use the federal exemptions or the state exemptions. The question is why? Because what might make one impoverished in one state might not be the same in another, right? It's more expensive to live in one. It's clearly more expensive to live in New York than, say, a different state that could be, south of us. I don't know. But I know that it's cheaper to live in the southern parts of the country than it is to live in New York. But depends on where you live, right? Cost of living. New York is a state that gives debtors the choice to use the federal exemptions or the New York exemptions. I am going to go through the common exemptions right here. The book does a laundry list of all the ones that are available with their particular amounts. Like I said, I'm not interested in the amounts. My amounts on my slides are going to be higher than the ones in the book because they're more current. But you just need to know the concepts, okay? And I'm going to give you some comparisons relative to New York so you can see the difference between a state exemption and a federal exemption. So in New York, the debtor can choose the exemptions. The homestead exemption is the biggest one, the equity in your home. People are like, oh, I get to keep my home if I file for bankruptcy. That's not an accurate statement. So the federal exemption, let's say it's approximately $23,000 in equity in your residence. If you don't use that, maybe you don't have equity in your residence, then you would be entitled to protect something else under that equity up to approximately $11,000. In New York State, that equity in your home is approximately $83,000. You see that? It's a very big difference. And I will tell you, New York also lays out, depends on the counties you live in. If you live on Long Island or somewhere near the city, that number is a lot bigger. And because states like Florida were giving full exemptions, because most people go down, they retire, and they go to a warmer climate, and they sell their big house, let's say in New York, and they buy a little house with all of their cash free to live in Florida as retirees, right? So now you got all of that. You don't have any mortgage on it. So the feds caught on to that and limited the amount that the state can give as an exemption, because Florida was given full exemptions to your home. Can't take any home, period. So they limited it. If you've acquired your home less than 3.5 years, you can only take 155. Well, just a little, almost 156,000. Or if you've lived in the state less than 2 years, you get no exemption. So the feds have made some limits. So for example, let's talk about the homestead exemption. Overall, you own your home. It's worth $100,000. You have a mortgage on it, that's $80,000. We take a Fed exemption. You have an equity of $20,000. So the $2,975 might be used towards something else. But nonetheless, you take the Fed, you could possibly take the New York, and then use the amount someplace else. There's also a limiting amount someplace else. But I want to show you that don't get mixed up in the math. I'm not testing you on the math, I'm testing you on the exemption and how it kind of works here a little. So $100,000 home, $95,000 mortgage. That leaves you with $5,000 against the equity, right? So you didn't use it all up, but you can use the additional 6, right? When you do the math, you subtract 5,000 from the 10, and you'll get the additional 6. So what if you own your home with no mortgage? You own a $100,000 home, you don't have a mortgage on it. That thing is getting sold, and you're only getting approximately $23,000. If you're in New York, though, you're getting approximately $83,000 back. But that's how that works. You're not going to be, oh, I get to keep my house. If you own your house outright, there's no security interest on it. You're only getting the equity that is claimed. And if you're in New York, it's 83, but 27 will have to come from someplace else. Some other exemptions, vehicles, the federal exemption, approximately 36. In New York, it's 45. So if you own an $80,000 Mercedes-Benz that you bought because you got an inheritance and there's no lien against it, they're going to take it and they're going to sell it. And if you're in New York, you're going to get $4,500 in cash. That's going to be your equity. Household goods, the general rule, $500 for one item, or a total of $12,250. There's a list of what's deemed household goods. It's in your book. Interest in tools of trade for your work or your business. Implements. Could be uniforms if you wear a special uniform, books that are related. Those are the federal numbers, and then the New York State number. Pensions are exempt up to $1 million. All public benefits are exempt. Public assistance, Social Security, veterans benefits, unemployment compensation, crimes victims compensation, any disability or illness benefits. Those are all exempt. If you receive any alimony or child support, those are all exempt. So look over, there's specifics regarding personal injury recovery, jewelry, things of that nature. You can take a look through those in your book. These are the main ones. So then what happens next, once we have taken the exempt property from the property that is subject to the bankruptcy, the creditors have to file within 90 days of that creditors meeting a proof of claim. So the question is, what's a claim? A claim under the bankruptcy law is generally is a right to payment, right? Whether or not it's reduced to a judgment, whether it's secured or unsecured, or disputed or undisputed, or liquidated or whatever, if you have a right to a payment, you have a claim. As a creditor, you are a person or an entity with a claim that arose no later than when the court issues the order of relief. So if the debtor owes you some sort of payment, that payment must have been due right up until where the court says, yeah, this petition is proper. The proof of claim, it lists the creditor's name and address and the amount that the debt that's owed to the creditor. That's it. That's all you need. So if the creditor fails to file the proof of claim, what happens? The creditor doesn't get anything. He can't receive a portion of the estate. But of course, even if they do file one, depending on who they are in the chain of payment, they're not guaranteed one because they file it. But if they don't file it, they're not going to get anything. Okay? So when the trustee is sorting out and examining property, they must determine whether the creditor has a secured interest in the debtor's property, and they may the debtor may decide to even just surrender the property to the creditor to satisfy the debt. That might be another thing that happens if we have a secured creditor and they've filed a claim, and maybe it's on a car or some sort of home lawnmower, and the debtor and the trustee might say, well, why don't you just take it back, and we call that good. That can certainly happen. So now we are talking about the property distribution. That's going to depend on who you are as a creditor. The trustee is going to do the distribution. They have to select, the priority among creditors. This is in the real bankruptcy world, it's very complex. This is going to be the general gist of it. Creditors, they don't have equal claims in the proceeds. So we have to talk about our secured creditors, and then we have to talk about our unsecured creditors. So our secured creditors, as we know, technically they're not part of these priorities because they never become part of the bankruptcy estate, because they have valid security interests. Even though they're perfected prior to filing of the bankruptcy petition, it's going to supersede any of the trustees' interests, okay? So these claims must be satisfied first to see if there's any assets left over from the bankruptcy estate before the trustee can supply any money to the unsecured creditors. So these folks are usually the mortgage company, the cars, things of that nature. So how does that happen? As I said, the debtor can surrender their collateral altogether to the creditor in satisfaction of the debt, or the creditor, and then the creditor sells the collateral and pays off the debt. If there's any surplus, by doing that, that surplus goes back into the bankruptcy estate. If there's a deficiency, then the creditor now becomes an unsecured creditor, and they get lumped into one of those classes under the unsecured creditors. So let's take, for example, Sandy Claus Corporation is a toy wholesaler who was petitioned involuntarily into bankruptcy court under Chapter 7 on July 21st, 2011. Keebler Inc. has a perfected purchase money security interest in some of the toys that it had sold to Claus. So Claus owes Keebler $30,000 and has not been paying Keebler or its other creditors' debts as they become due. Okay? So under the Chapter 7, the trustee has been selling assets and liquidating things, and they sell the toys. Sure, Sandy Claus may have wanted, maybe they could have taken the toys back, but in this instance it made sense to sell the toys through the bankruptcy proceeding. However, they are not out their $30,000 for choosing that. So the question is, how does this get distributed? Keebler is paid in full because they had a secured interest, and then the remainder of the money will go into the pool for the unsecured creditors, or the next class in line. So if there is a secured creditor with a security interest, they're going to get paid first. And then we have our unsecured creditors, and they're divided into classes. And again, I got to say, the book does a good job at sorting these folks out in more detail. I'm going to point out the main ones here. These creditors, they're paid in a certain order of their priority, and they're divided into classes. And each class must be fully paid before the next class in line is entitled to any proceeds. Okay? So if there's insufficient funds to pay an entire class, so if we're only on class 1 and there's not enough to pay the entire class, the proceeds are distributed proportionately to each creditor of the class. So someone's going to get something in potentially class 1, not just some of them and not all of them. So if you're already doling out money in a class, it has to be kind of split proportionally in even amounts. So sadly, classes that are low on the priority chain, you usually get nothing, okay? But if in the end there's a surplus, the remainder goes to the debtor. So let's talk about these main ones. The domestic support obligations, they're getting paid first. These are the folks that have claims for spousal support, former spouses have alimony payments, or child support payments. Those are going to be number one after the secured creditors. Those are the folks that are going to get paid first. Number two is administrative expenses. What do I mean by that? These are the expenses required to administer the bankruptcy. It's the trustee's fee, appraisal fee, attorney's fees, expenses for doing, like I said, appraisals, but for selling and retrieving property. Those things cost money. Even though the statute has lumped this as number two, there is a slightly gap, and these are usually paid out before. Actually, what's happened is these amounts are deducted and set aside before even paying out number one. They don't technically get paid out first, they'll get paid out second, but the courts allow this little de facto priority. And it gets set aside, it'll get paid second, but it's really technically first. Why is that? Because no one's going to work for free, right? You're not going to have a trustee that's going to do all this work and then not get paid. So that's usually deducted right off the top. Then we have this gap creditors. This is when involuntary petitions are filed. Creditors who lend, these are creditors who lend the debtor money during the bankruptcy, and you might be like, why would they lend money in the bankruptcy if they forced them in the bankruptcy? We're talking about a business. They might think that doing business and keeping this business in business is more important, so they would, rather than liquidate, they want to keep them in business. Employee wages get paid fourth. Unpaid contributions to employee benefit plans. Any claims for grain from a grain producer or fish from fishermen. Consumer layaway deposits up to $2,600. For example, Mary placed a $3,000 deposit for a $10,000 wedding dress at Barb's bridal. Before the dress was delivered, Barb declared bankruptcy. Mary's claim for $2,600 would fall into this level, but that doesn't mean she's out the $400. That $400 will get dumped down to our number 11, which is our general creditor pool. Taxes. This is a big one. Maybe this surprises you that taxes owed to the federal government, state government, and local governments is way down here at number 8, right? Yep, outside of the bankruptcy, they have the highest priority, as we talked about when we were talking about liens and mortgages and secured interests. That's why creditors actually like to file for involuntary bankruptcy, because they get a higher priority, especially the secured ones. But taxes are way down on the list. Obligations to an insured bank, because the bank can get paid elsewhere. Debts that are arising from motor vehicle accidents involving DWI, drinking while intoxicated, or drugs while intoxicated. And then you have the general pool of creditors. If you make it down that far, this is where our credit card companies fall into. And here's my Mary example. If you want to go through it again, you can work through it here. What's Mary's claim? Her claim is for $3,000, not for the $26,000. Even though that's her cutoff for the layaway, right? It's an unsecured debt, and what class she is in? She's in the consumer layaway. And how is she going to get the distribution? I just gave you that. She'll get her $2,600, but the $400 goes into the general pool. And that's, of course, if they make it all the way down to number 7 on the list after paying out all of those other folks. So who knows if she ends up with anything at all. It's going to depend on Barb Bridal's situation. And then discharge. That's the last component. This is the whole point of bankruptcy, is for the debtors to get relief from the pressure of debt that they cannot reasonably pay. So once the proceeds that have been distributed, the debtor's remaining debts are discharged. What does that mean? That the debtor is no longer legally liable to pay any remaining unpaid debts that arose before the court issued the order of relief. So any actions involving any of the estate items, estate property, can no longer be litigated. The key is that to get discharge, you have to be an honest debtor, okay? And there are some exceptions to what can be discharged. I'll get to those in a second. So the discharge voids any money judgments against the debtor and bars any creditors from seeking judgment. So it's a clean state, fresh start. To be discharged, the debtor must be an individual. Why? To get a discharge under Chapter 7, we call it a liquidation. And why do you have to be an individual just to get a discharge? Because if you discharge a bankrupt business organization, like a corporation or a partnership, like they cease to exist because all their assets will be liquidated. So the point is to give a fresh start to an individual. So to get a discharge at the end of a Chapter 7, while partnerships and corporations can all get to that point, the debtor has to be the one, the individual debtor will get the full discharge unless the business wants to liquidate. So you must be an honest debtor. What do I mean by that? These are acts that will bar someone from discharge. If you make false claims against the estate, you conceal property. You transfer property after filing with intent to defeat the law, i.e. those fraudulent transfers. Refusing to obey court orders. Destroying, falsifying books, accountings, failing to file satisfactory explanations for any loss of assets. Debtor must, and then the last one is individual abuses of the bankruptcy process. And you need some sort of bad faith. I'm going to give you some examples here. So David and Sharon Welsh, they file it for bankruptcy. The bankruptcy trustee objected to the Welsh's proposed plan for payment. The trustee argues that it was not proposed in good faith because of a minuscule payments to the unsecured class while they lived in a $400,000 home and bought unnecessary items. The trustee argued that the couple failed to commit 100% of their disposable income to the plan. Specifically, they excluded their Social Security income, and as a result, the plan would only pay about $14,000 of the $180,000 of unsecured debt. So the question becomes, are they acting in bad faith here? And the court said, when you look at the Bankruptcy Code and you're following the rules of the Bankruptcy Code, i.e. Social Security income is exempt income, they don't have to claim it, and that the code requires certain expenses to be subtracted, that as long as they're operating within the code, it's being done in good faith, no matter how it looks on paper. And clearly there's a big discrepancy between $14,000 and $180,000 of what they're proposing to pay of the unsecured debt, and that certainly looks alarming, but as long as the debtor is operating within the code, it's okay. Some other examples I would like for you to take into consideration. So a debtor has an automobile worth $5,000. The federal exemption, as we said, applicable to this debtor would be approximately $3,200. So the trustee sells the car and gives the debtor the amount of the exemption. And the debtor is done. She's so exhausted by the bankruptcy proceeding, she takes that money and spends it on a 6-week vacation in Mexico. The question is that abuse of the bankruptcy system? And unfortunately, the answer would be no. You might be like, whoa, she got $3,200. Why isn't she paying off her debt with that? Why is she going on vacation? But she got the exemption, and the law allows for her to get that exemption. You're free to do what you want with it. On the flip side, a debtor has $500 in cash beyond what is exempt in bankruptcy, meaning she has disposable income. She takes the cash and buys new tires for her car, which is worth about $2,000. And the question is this an abuse of the bankruptcy system? And you might be saying, well, no, she needs the tires to keep her car running, and she's, got that exemption possibly. But you don't get to, like in the house where you get the extra equity in your house. That doesn't work for cars. And I didn't put any information in the example relative to what the trustee did with the money, but this is suggesting that the debtor has done her means test and now she has $500 in cash beyond what's exempt. So technically it's disposable income. She can be subject to dismissal here. Or an abuse, I hate the word abuse, but that's because it has a different kind of meaning. But that could technically be considered abuse in those two extreme examples, right? One is operating through the code. The other one just took the extra money and bought something else. Those things have to be cleared with the bankruptcy trustee. So the second one might be deemed an abuse. Debts that are not discharged, regardless. If you didn't list, a debtor that doesn't list anything on the petition is not dischargeable. Student loans are not dischargeable unless there's a showing of undue hardship. We're not going to talk about that when we talk about bankruptcy. It is a very hard standard to meet. Taxes are not, even though taxes are very low on the payout list, they're not ultimately dischargeable, so the government can continue to come after you for your taxes. If you owe any fines for violating the law, you got a speeding ticket and your fine's $500, it's not dischargeable. Any alimony, child support, any payments relative to a divorce are not dischargeable. Debts that were the result of any theft or embezzlement, debts for any personal injury caused by DWI, drinking while intoxicated, or drugs while intoxicated, any debts arising out of fraud, and any violations of the security laws, basically violating any law. This is certainly not the exhaustive list. The book's list is a lot longer. These are just the majority, the main ones, most common that I like to point out. And you may be listing these things. The point I want to make is while these things might be listed and have to be listed on your voluntary petition, you will still be responsible for paying these things if they're not paid through the bankruptcy. They are not dischargeable. Can your discharge ever be revoked after you are discharged? Yes, it can. If it has been discovered, either by the trustee or a creditor or somebody else, but usually it's the trustee or the creditor, discovers that the bankrupt or the debtor committed fraud during the bankruptcy proceedings, whether it's unknown to the creditors seeking the revocation, the court can revoke your discharge within 1 year of ordering it. So a debtor, for example, conceals an asset in order to defraud creditors. That doesn't come out during the bankruptcy, but it's found out within a year after discharge. Your discharge can be revoked. There's this concept called reaffirmation. This is the debtor promises to pay a debt that will be discharged. Why would they want to do that? The debtor maybe the debtor owes money to a family member or a business associate, and they want to maintain the good relationship, possibly. They may choose to repay this debt rather than be discharged, but the code makes it very hard, or I shouldn't say it doesn't make it very easy, because they don't want people to make these decisions very hastily to do that. So in order for a affirmation to be enforceable, the following things must be met. It takes place before discharge, so it has to happen before the discharge. It has to be approved by the court. Anytime a debtor wants to repay a debt that can be discharged, it has to be approved by the court. The debtor is allowed 60 days to rescind once they agree upon it. The debtor must be provided warnings by the court or from an attorney and affirms that they got the warnings. The effects of doing the reaffirmation, meaning they can never be discharged from it if they choose to pay it, because you have your opportunity now. And you can't come back in a few years, 6, 8 years from now, depending on how you're discharged, to ask for it to be discharged. It's once you agree, you're stuck with it. If the debt involves consumer debt, not secured by land, real property, the court must approve the agreement as being in the best interest of the debtor and doesn't impose any undue hardship. So if it's consumer debt that they're promising to repay, the court must make a finding that it's in the debtor's best interest for agreeing to repay and that it will cause no undue hardship. So that is Chapter 7, and this is my little flow chart of the process. You get your information, you do your credit counseling course, you file your case, you meet with the creditors get their notice. Sometimes there's an additional meeting once we know we have all the proof of claims and such. You take the debtor takes their financial management course, bankruptcy. And during the course of this, the bankruptcy trustee is collecting the property and either selling it, organizing it, and doing what the trustee has to do, and then files the report with the court, and then 4 months later, it could be discharged. And Chapter 7 is fairly for an individual, I don't want to say an easy process because it's very emotional, but it's something that doesn't last forever in the courts. Now I have Chapter 11 reorganization starting along with these slides here. I am going to stop here because it's been about an hour and 20 minutes. This is just going to be Chapter 7 liquidation. That's how I'm going to post it on Moodle, and I'm going to have a separate slide situation for Chapter 11 and Chapter 13, which won't be that long. I don't think it'll be longer than 30 minutes, but I organized this outline for my in-class course, so this is going to be a little bit longer set here. So I'm going to stop this recording right here. You can certainly look through the rest of the slides, but Chapter 11 and Chapter 13 video will be on a separate video.